All right, good afternoon, everyone, and thank you for joining us today. Today, our webinar, Up to the Minute Employment Law Updates, is hosted by the Association of Legal Administrators, a premier professional association connecting leaders and managers within the legal industry. Special thank you to Cynthia Schuler, Brenda Simoes, and Julie Hooper from the DC ALA chapter for organizing the event today. Our presenter is Thomas L. McCally. Tom is an equity partner from the law firm Carmelone PC, a business and litigation firm serving the Mid-Atlantic. Tom has over 25 years of experience as a litigator, business advisor, and outside general counsel across a variety of industry groups. Tom is also Carmelone's employment and labor law practice group leader, regularly representing clients in federal and state courts, as well as practicing before the EEOC and state/local EEO agencies. Before we get started, I would like to kindly ask all attendees to make sure their mics are muted and videos are turned off for the duration of this presentation being recorded today. Please type in your questions in the drop-down chat box, and your questions will be addressed throughout the presentation. A recording of this webinar will also be provided to registered attendees. Now I'll hand it over to Tom for today's presentation. Thank you.
Thank you, Erin, and good afternoon, everyone. I hope you're all doing well as we keep going through the COVID protocols. As you can see, I'm in my office. I hope you out there watching are in some exotic place working virtually, but some of us are back in the office from time to time. As with everything during COVID, things change rapidly, and the same for this presentation. One section we were going to cover was pretty much wiped out last week by moves the Biden administration made to address changes in various Department of Labor rules and regulations that the Trump administration had put in. And I'll get to that in a moment, but it will give us the good news. We'll have more time at the end of the presentation to talk about questions you might have, etc. The other item, Erin said questions throughout the presentation. That's fine. If you could try to hold any questions until the end of the section, and I will try to remember to prompt everyone if they have any questions. The topics we're going to cover today, the first one was going to be the independent contractor new regulations that were set to go into effect in March. That's now not going to happen. We're then going to cover some federal guidance on posting requirements. We're going to cover non-compete laws in DC, Maryland, and Virginia. And the final topic will be COVID and EEOC guidance on the return to work and vaccinations for employees, as well as some practical information we'd like to impart, as well as takeaways for reopening of your offices. But to begin, we're going to turn to the first section of the presentation. That was going to be about the new independent contractor standard rule. That was all relevant until last week. It was set to go into effect in March. They proposed a delay until May, and now with the new administration, the Department of Labor has withdrawn its opinion letter from 2019. That was the basis for the Trump Department of Labor enacting what we call the economic realities test for determining whether an individual is an employee or an independent contractor. Everything right now is kind of on hold because of that withdrawal of the opinion letter by the Department of Labor. So where does that leave us in determining what an individual is, either an independent contractor or an employee? We're kind of in limbo. I would not recommend making any changes to any independent contractor agreements that you may have in place right now. Arguably, we've reverted back to the Obama era Department of Labor that had a test called the Administrator Interpretation Test, which was much broader in that it tended to find almost everyone to be an employee as opposed to an independent contractor. With President Biden's guidance now and what the people are talking about. They're not sure which way he's going to go, but it looks like he might have our Department of Labor adopt the California test, which is known as the ABC test. And essentially what that test looks at, they look at the hiring entity and whether or not the individual is free from all control by the hiring entity. Number two, they look at outside work. Is this independent contractor just doing the work that your business does? If it is, if that he or she is, then that's going to look more like an employee as opposed to an independent contractor. And the third element, is it truly an independent business, your independent contractor? In other words, does he or she have other clients? Are they doing the same type of work for a bunch of other clients? That's the California test in a very compact way. The administrative interpretation test, again, that was very broad, finding almost any control exercised by the entity hiring the independent contractor that could amount to becoming an employee situation as opposed to an independent contractor. Without getting into any detail on that, because we don't know which way the current administration is going to go, what I can tell you, it is going, whatever changes get made, it will be likely, based on what the literature is saying, more friendly towards finding independent contractors to be employees. And I'm just going to skip through these slides that we were going to do, because the economic reality test is now kind of dead. The other thing that happened recently as well is the joint employer status under the Fair Labor Standard Act. Another executive, or not executive order, but President Biden's Department of Labor has issued action items that look like they're going to take another look at the joint employer under the Fair Labor Standard Act. So both of these issues, at least as far as the federal Department of Labor are concerned, are up in the air, and in interpreting the Fair Labor Standard Act as to whether an entity is or is not an independent contractor, and whether or not there is or is not a joint employer agreement. Again, I would not make any changes to the documents you have now. We have to wait and see what the Department of Labor is going to do. Also, keep in mind, each one of the states have their own rules and regulations. I would say that if looking at DC, it errs more on the side of the economic realities test, looking at indicia of control exerted over the individual, whether they're an employee or independent contractor. That same test generally applies for the joint employer rule as well. They look at indicia of control, in addition to other things, but they focus heavily on who controls the individual. Are there any questions about where we are with that? I know it's kind of in limbo, but if you have any questions, you can certainly put them in the chat room and I'll try to address them. All right, seeing no questions, well, this was a topic that the ALA wanted addressed, the non-competes in the 3 jurisdictions. There is a lot of change in non-competes across the country, and what I would say as a general statement, non-competes are falling into disfavor with all jurisdictions. And as we see as we go through this section of the presentation, Maryland and DC and Virginia are treating them differently, but many other states, New York and states up in the Northeast, as well as California, do not permit them. They are just simply not enforceable. They're void as against public policy. Something particular for law firms that everyone needs to be aware of: lawyers cannot be subject to non-competes. That's based on the model rules of professional conduct. Every jurisdiction tends to follow this. I don't know of any law firms that try to enforce non-competes with their attorneys. There is an exception to that, and as is set forth here in Section A, that exception concerns agreements concerning benefits upon retirement. And what we see a lot of law firms for a partner retiring, there is usually a monetary component to that. And the reason that doesn't fall under this prohibition of the model rules is because it's not preventing them from competing or going out and working again. They can do that, but they will lose that monetary benefit. And that's how most operating agreements are set up. And if there is ongoing payments to the retiring partner, they usually prohibit that partner from engaging in competition. Keep in mind also, in the District of Columbia, law firms cannot penalize departing attorneys who leave and takes clients with them by making reductions to compensation or other non-retirement related benefits. So if it's related to a retirement benefit, you can have a restrictive covenant that's usually tied to money. If they compete, they won't get paid. But just a lawyer leaving your firm going elsewhere, you can't restrict their ability to do that. With that general overview of the ethical considerations, those would not apply to staff members. Many of my law firm clients do have restrictive agreements with various staff at certain levels. Those are still enforceable if they're in effect now, but the new DC law will make any new non-competes unenforceable, and we'll get to that in a moment. Let's start with Virginia. And what we're seeing with non-competes, some are geared towards the wage as the discerning factor. Others are just blanket bans like DC. So for Virginia, theirs is a wage-based, and it only applies to what they call low wage earners, but the rate is $62,608. So if someone is earning that or less, they cannot be subject to a non-compete. It's a pretty high wage, I would say, compared to some of the other states that we see who use a wage determining factor. With that said, this figure, you'll have to look at the statute. It varies and fluctuates depending on a variety of factors. So if you're considering implementing non-competes for individuals currently earning less than $62,608, you should look at the statute to make certain that it hasn't changed by the time you implement any restrictive covenants. The Virginia rule, and again, not every state's the same, but it does create a private cause of action for the employee. And that employee is entitled to injunctive relief. That means the contract is unenforceable. They can go work. It also provides for liquidated damages and lost compensation, as well as attorney's fees if the employer implements a non-compete and tries to enforce it. The Virginia Department of Labor, it has civil administrative penalties that the state can impose. I would tell you Virginia's are the highest at $10,000 per violation. Other states and jurisdictions are lower than that. Exemptions, and this is true for all the statutes we're going to cover. Most of these are. The exemptions that apply in Virginia to non-competes are sales commissions jobs. So if someone is working in a commission position, even if they're earning under 62,000, the non-compete, you can have a non-compete for them. That's one exemption that was put in the statute. The second one here on the second bullet, it does not prohibit confidentiality agreements or non-disclosure agreements that prevent departing employees from releasing confidential proprietary information, and that would include client lists. So you can protect your client lists through a restrictive covenant that is built into a confidentiality non-disclosure agreement. and we'll look at DC, the same exemption applies, and I'll have some advice on that when we get to DC. The Maryland non-compete, it was effective in 2019. Again, you cannot have a non-compete or what they also call a conflict of interest provision in any agreement with an employee earning $31,200 or less per year. That equates to about $15 per hour. Again, a wage-based non-compete provision. People who are above that, they can have non-competes, at least for now. The conflict of interest provision is interesting in that many employers have tried to institute a non-compete, but they do it through a conflict of interest by saying, well, we're not competing you from working, but if you go to work for that company, it's a conflict of interest. That's covered by the Maryland law as well. So no non-competes in Maryland for individuals earning less than $31,200 a year. Again, the non-compete exemptions for Maryland apply to confidentiality. Non-disclosure agreements are exempt, and that would even include agreements with respect to client lists or other proprietary client-related information. So again, if you have offices in Maryland, you may want to look at any non-disclosure or confidentiality agreements that your employees sign. Make sure client lists are put in there and client-related information as well. It would do you well to take a look at those agreements for all three jurisdictions. In terms of penalties, the Maryland statute is quite interesting. The law doesn't really have any penalties in it for violating the law, and it doesn't specifically or statutorily create a cause of action for the employees. So what you'll expect to see if someone tries to enforce a non-compete against an employee in Maryland earning under $31,000, you could expect to see them going to court for injunctive release, asking that the court find that provision to be null and void as against public policy. For Maryland's interesting in that it did not create a private cause of action, nor does it have administrative penalties that can be enforced by the state. The district, this is our new one, brand new, not enforced yet. If it gets by the 30-day congressional review period, which I have not seen anything to indicate it will not, it will become effective on March 19th, 2021. It does not apply retroactively. So if you have non-competes in place now, or there's someone you want to get under a non-compete other than a lawyer, now's the time to do it and move quickly. Who does the act apply to? Like anything in the district, it's it's all encompassing and also somewhat vague. So it applies to all private employers and applies to almost all employees except medical practitioners. And there's an exemption for the occasional babysitter. Haven't figured that one out yet, but they're exempt. Medical employees earning over $250,000. This does not apply to. They can be subject to a non-compete. But it also applies if an employee expects to be working in the district. And what that means will be determined by the courts. It's not really directed at the occasional work in the district, but if it's more than occasional, even though they're not located in the district, but they come into the district or could reasonably be expected to come into the district, they can't be subject to a non-compete. There are exemptions for nonprofits and religious institutions. That doesn't apply to for-profit businesses or law firms. But it is very broad in that don't feel that you're necessarily safe just because the employee doesn't routinely come into the district. if you're thinking about putting them under a non-compete. And this is even more, you have to pay attention to it even more with all the people working remotely. Just because they're working remotely doesn't mean this may not apply to them if you as the employer are based in the district. So keep that in mind. And the restriction is no non-competes. They do have the exemptions, and we'll get to those in a moment, but it does not have a minimum salary cutoff for it to apply. That's very important to remember. It applies to everyone, every job, period, except those specifically exempted that I mentioned before. The other interesting thing here that can or could create a problem for law firms is that not only does it apply after this prohibition that you can't have a non-compete, it applies after the employee leaves your firm or company, but it applies while they're employed, okay? So think about that for a law firm for a second. You could have an employee, maybe a paralegal, or any type of employee, staff, or something like that, or it could even be an attorney or an associate who then has another job, has a part-time job. Traditionally, we have been very comfortable saying in our employee policies and manuals and things like that, that you have to devote your full time and attention to this job. You shouldn't have any outside employment, etc. Keep in mind, under the District of Columbia Human Rights Act, you cannot discriminate against an individual for their place of employment. And that means full-time or even part-time. So I'm just going to take a paralegal, for example. What if you had a paralegal who's working in your firm, and then you find out they're also working part-time on the weekends at another firm, and you happen to have a case against that firm? Could that create a conflict of interest for your firm in that representation? And can you prohibit that employee from working that part-time job or let them go? Obviously, the statute's not even in place yet. There is no case law on it. There is no interpretation of what that would mean in the situation I just presented. I would argue that you're not trying to prevent them from competing or working, but I would put it in the framework of an ethical conflict of interest if you want to try to make that person stop working or moonlighting at another firm. It's something to keep in mind. You may never come across it, but if you find out an employee has another job and you don't like it for some reason, keep in mind this statute, when it becomes effective, could prevent you from having that employee stop working in that other capacity. And the DC Human Rights Act could be folded in with that to give them a broader cause of action if they decided to challenge that, that your attempts to stop them from working or you terminated them. So it's just food for thought. It's of particular concern due to conflict of interest for law firms. So I think you should keep it in the back of your mind, be aware of it, particularly once March 19th comes and it's in effect. Now, again, the DC Act, like all the others, it has exemptions. It does not apply to confidentiality agreements or agreements that restrict the use of employers' trade secret, proprietary information, customer lists, etc. The one instance in which it doesn't apply, in other words, you can have non-competes, is in the sale or purchase of a business. So the law specifically carves out, let's say, an acquisition or a merger where you're restricting the ability of the people who own or run the company being purchased from working. That is permitted, okay? That's one of the specific carve-outs, in addition to confidentiality, trade secrets, etc. Of interest, the DC statute does not specifically address covenants against soliciting clients. You can't stop that for a lawyer. If you're a law firm, clients can choose any lawyer they want. So it doesn't really apply there, but non-legal or positions that are not lawyers, you might be able to, as part of your confidentiality trade secret agreements, if you're using them, have a non-solicitation provision of your clients. I would look carefully at the statute once it's enacted, because there could be more changes, but something to keep in mind about that as well. This is like everything in the district, you got to give notice. And this one's particularly interesting and onerous. It doesn't say you have to post it, but you have to give it specifically to the employees. So this is the language. If you're using non-competes, you got to use this language, the specific language. So you can lift it right from here if you ever need to do it. And here's the notice that you have to give under the statute. All employees, and this is whether you're using them or not. Okay, so this law requires all employers to give this notice, not just if you have non-competes. 90 calendar days after the act becomes effective, I almost said offensive, but once it becomes effective, you have to give that notice to your employees. Number two, 7 calendar days after an employee is hired, you have to give them that notice. So what are we going to do here? This is going to be sent out. The cover number 1, you're going to do a broadcast email to your employees, and I would recommend posting it where you post your normal employment postings. Number 2, your new hire packet is going to have this form in it, and you'll have the employees sign off on it. Or if you do it electronically, have them acknowledge electronically that they got the notice. Now, the third requirement is 14 days after the employer receives a written request for the notice. So keep that in mind. You get a request, you've got 2 weeks, okay, to give them that notice. Hopefully, if you've complied with 1 and 2, you won't have any problem with that. Again, this act, the DC Act, it, like others, does provide for a private cause of action, as well as the employees in the statute. If it passes this way, they're almost encouraged to report to the governor's office. And the attorney general can then investigate and has the ability to fine up to $1,000 any employer who violates the act. So make sure you get the notices out there. Don't miss those deadlines. If you have non-competes or you're thinking about them, make sure you check the status of the act, make sure it hasn't been changed, and always remember it has a private cause of action. So you're subject to attorney's fees, potentially lost wages, and liquidated trebling of any damages. So keep that in mind. I see we might have some questions about the non-competes. So I'm done with the non-compete section. Let me look in the chat. So the first one, not all of our attorneys are working remotely. Do non-compete laws apply to the state from where the attorney works or where the firm is located? If you're located in DC, it applies to you. Okay, so it applies to DC employers and also employers outside of DC whose employees are working in DC. Next question, can we ask to tell us if they work for a competitor but not require disclosure approval? So if I'm in a law firm, and assuming this statute comes out the way it's written now, I would want to inquire or have a policy that if employees are working at other law firms, that they let us know, because of the conflict of interest, the ethical concern I have. There are cases out there where non-lawyer employees have worked at firms that their main firm was in litigation against and information got transferred back, et cetera, there have been malpractice cases like that and other types of litigation. So as things stand right now, I would want to know if employees are working at other law firms about that because of that conflict of interest issue. Broader than that, where else could they be working? As I sit here right now, I don't know that I'd want to know, quite frankly. If it comes up and you learn about it on social media or someone tells you and you have a legitimate business concern, as the statute reads right now, and as I sit here right now, it might be worth asking. The question about should you update your policies about outside employment? Yes, you should at least take a look at them and make sure that they're compliant and not in violation of this statute. Where can we attain the appropriate language to be used for the non-compete notice? It's in the slide that I just did. It was the slide coming into this session. It's quoted in that slide. And the presentation will be made available if you don't have it already. Where can we attain, that was it. All right, I think that's all the questions that I see. Yes, we'll get you, we'll send out an email about how to get a copy of the slide deck. Aaron can take care of that. Again, asking if they work for a competitor, if you mean a competing law firm, I think that would be appropriate as things stand right now, because I don't know what the final statute will be. But I think it would be appropriate if you're a law firm because of the conflict of interest issue. All right, I think we covered them all. All right, we're moving on to the federal posting requirements. And this is something, again, we recommended to the ALA that this be covered, and it was agreed upon. With the increase in remote working, what we're worried about or concerned, not worried, but we think you all should be on top of this. Posting in the physical office when no one's going in there probably isn't going to cut it anymore. We don't want you falling into a trap that someone says, oh, these required postings weren't up, I didn't know my rights, et cetera, et cetera. With that said, the Department of Labor has come up with guidance about posting. Now, keep in mind, it's the Department of Labor, so it only applies to federal statutes. And the specific statutes are the FLSA, Fair Labor Standard Act, overtime, et cetera. FMLA, that's federal FMLA, the Polygraph Protection Act, and the Service Contract Act. If you have your standard federal poster up, all that's there, and it's somewhere in your physical office. What the Department of Labor is allowing, although I don't think they went far enough, is they're allowing for electronic posting in certain instances. You can go to the link, it'll take you right to their website, and it will tell you what they have essentially agreed to for electronic posting. The problem is it starts out with if you have no physical establishment where employees are employed or interviewing or hiring takes place. So I just don't think that's broad enough. You should be able to post electronically, period, in my opinion, but we're not quite there yet. So you have to keep your paper postings up in the physical office, but then I would use this guidance as a good reason to create your own electronic posting system within the firm. And the reason for that is what I just stated. We don't want you running afoul of posting or giving or an employee being able to make an argument that they were unaware of these laws and therefore bring a claim against you. So what do we recommend in light of that guidance? An email posting, that's one way to do it. I think the better way is some internal intranet or electronic bulletin board that you keep on your system, that all employees are made aware that it's there and all the postings are there, and have those postings track what you're required to post in the physical office. I would do that for any jurisdiction in DC, Maryland, and Virginia. I think it's a good idea, particularly because we don't know what the future is going to hold. Are more employees going to be remote, or more going to come back in the office, et cetera, et cetera. By doing it electronically and then the traditional paper posting, you're covering all bases. I would also recommend some form of evidence that they've acknowledged that they're aware of the electronic postings. So for example, you send out the blast email with the opening announcement about your electronic bulletin board that has all required employment and federal postings. You have your employees reply received. Something of that nature so you can document they got it. On your hiring packet, have a form that says everything's posted on the electronic bulletin board. If you have any questions, here's how you get to it. Have them sign that as part of the onboarding process. Something, again, that's not required, but we think it's a good idea to do as we move more into the virtual world and as we start to come back to the workplace and there's a real mishmash of employees being in the office and out of the office. And even more important for those employees who are never coming into the office, who have moved, to another country or something, but are continuing to work. That's it for this section. Any questions about posting electronically or what the feds are saying about that for the federal postings? Okay, I don't see any questions. We'll move into the next section. I skipped the slide. And here we are. This is the COVID related section. Now, my caveat here, everything I'm telling you right now could change tomorrow, okay? It could be changed by federal government guidance. It could be changed by a spike in positive testing in some jurisdiction. Your own state or county where your offices may be could issue different guidance. So keep that in mind, and we'll talk about employer takeaways at the very end. But what I thought would be very interesting and necessary is the question, can you require employees to be vaccinated? I'm sure you've all read a lot of stuff about this. So I'm going to go through the EEOC guidance that was issued in December. The short answer is yes, you can require it for employees returning to the workplace. But in doing so, you have to keep in mind there are ADA implications, meaning the person may have a health reason why they can't get vaccinated. And then you're going to have to go through the individualized assessment and reasonable accommodation protocol to determine if that employee can come back to the workplace or not. Next, there is Title VII religious exemption. And keep in mind, under Title VII, people with strongly held religious beliefs, if their belief is against vaccinations, and there are various religions who, depending on the vaccination and its source, it's against their beliefs to take it. That would trigger Title VII. And again, you would go through the individualized assessment and reasonable accommodation to determine if that person can return to work without getting vaccinated, or whether there's another reasonable accommodation so they can keep working without bringing them back to work. And that's what we're going to go through in these slides. So the Americans with Disabilities Act, and this could be a whole day on this stuff with what employers are doing in terms of temperature taking and things like that. But I'm limiting this to requiring vaccinations to return to work. So can you do it? Yes. Requiring a vaccination or proof of it is not a medical examination or disability related inquiry. So you're okay under the ADA up to that point. Information obtained during the vaccination process that puts you on notice of a disability, that's a different story, and that triggers the ADA. And then the individualized assessment and reasonable accommodation kind of protocols. Now, under the current guidance, and this is interesting, this is from the EEOC's guidance. It talks about employers administering the vaccine. Well, right now, our governments don't get enough of the vaccine to administer it to everyone. So some of this isn't really relevant right now, but in the future and years to come, it could be. And you may be an employer who can get the vaccine and distribute it or administer it. So this may be relevant down the road. But if you are administering it through your own processes, or you hire a third-party contractor to come in, when they ask questions about giving shots, and there are specific questions they have to ask about reactions to the vaccine and other medical questions, that could very easily trigger information about a disability coming out. And so the point here is whether it's you or a vendor you hired to come in to do it, you could be under the same umbrella as having knowledge of a disability, even though it just went to your vendor. Okay. You want to be so if you're doing this down the road, you want to be careful about the questions you ask. They need to be job related and specifically related to the vaccine in order to ask those questions. All right, that scenario is probably down the road. None of us have access to the vaccine on a private basis or anything else. So let's look more realistically. What are you going to do? The simplest way to avoid all of that is just to require proof of vaccination. And very easy to do. When you get vaccinated, they give you a form that shows that. There is literature that has been coming out, and Aaron just showed me an article about it, about a recorded vaccination passport. That may be down the road and required by jurisdictions. We don't know, but it's going to be very easy for your employees to get proof of vaccination. So you can request that. That way you don't have access to any of the information about why they did or couldn't get it. So all you need to see is the vaccination. They can come back to work if that's what you want them to do. You should also consider, if you're not, you may not have to require vaccinations for all employees, depending on where they work. You know, for example, if you have a group of employees who are isolated in an area and they don't want to get vaccinated and they're not interacting with anyone, then you may not need to, you may not want to require them to get vaccinated, as long as you can maintain that they're going to be in a limited area, not interacting, etc. Now, if the employee refuses or is ineligible to get the vaccine, but wants to come back to work, okay, they want to be back in the office, or you're requiring them to come back and they don't want to get vaccinated. So now you're thinking, look, your job has to be done in the office. We may have to let go of you if you can't get vaccinated. Why can't you get vaccinated? So once that employee comes to you, they're probably going to tell you about a health reason or a religious belief. What does that trigger for you? The only way you can exclude them is if they pose a direct threat due to a significant risk of substantial harm to the health and safety of themselves or others, meaning the rest of your workforce, that cannot be eliminated or reduced by reasonable accommodation. So that's the individualized assessment. And the third bullet point are the factors the EEOC says they want you to look at. Number one, the duration of the risk. What does that mean? Is it that the person can never get vaccinated, or they got to wait a couple weeks for some reason? That's an example. Now, the second, nature and severity of the potential harm. Again, if this employee works in an isolated area, doesn't really interact, maybe there's not as big a risk of harm. If that employee is interacting throughout the workspace, meeting with clients, or being sent to a client's headquarters or something like that, that increases the nature of severity and potential harm. Next bullet point, the likelihood that potential harm will occur. I don't know how you gauge that. If most of your workforce is vaccinated, is he or she who doesn't want to get vaccinated, are they going to impact the workplace or infect someone else? Well, I guess the argument would be, no, 90% is vaccinated, it's not going to make a big difference. And finally, the imminence of the potential harm. Is this real harm? Is this something that is likely to happen? Or is this your speculation about what could happen in terms of harm? And what they don't go into in the guidance, what does harm mean? Is harm to your business potentially that no one else will come into work if, say, Tom doesn't want to get vaccinated? So other people say, well, I'm not coming in. I think that's a fair assessment. An economic harm to your business is part of the harm. So once you've gone through that individualized assessment and you found it's a direct threat, what the EEOC guidance also wants as part of that is what I said earlier. What is the percentage of your employees who have been vaccinated or who could be exposed? So they're looking at that as to whether is this person just one of a few who hasn't gotten it, or are they one of many? That's got to go into your decision making. So now, if you've come to that point and they're a direct threat, and now you're thinking we got to let you go, now the reasonable accommodation comes in, and these typically go hand in hand. So if you find they pose a direct threat, you still have to go through the reasonable accommodation to determine whether or not there's a reasonable accommodation that you can make in order to bring them back that would minimize that direct threat and or undue hardship. What does that mean? And right now in today's world, virtual working is the first thing that comes to mind. So an employer is going to be very hard pressed to say you can't work virtually. Now, if this particular job requires them to be in the office, that's another story. So what are you looking at them? Can they be isolated? Can they be petitions around them? Can they work in a closed office? Can there be increased cleaning? All of those types of things, and things I haven't even thought of, would go into the reasonable accommodation decision. So if you find a reasonable accommodation, you got the employee arguably has the right to come back into the workplace, even if they're not vaccinated. Now, if there is no reasonable accommodation, and I would encourage you to consult with counsel before you make that determination, then the EEOC guidance still says that doesn't mean you can terminate them, because now you need to look at other accommodation laws, including leave laws, okay? And right now we have in Congress the AID Act. Part of that has increased leave laws that could be implemented. So we don't know where that's going to go. but they would be entitled to use their FMLA leave if they have it. You may have a leave without pay program. They'd be entitled to use that. So you have to look at all of those other items before you can terminate that employee because they won't get vaccinated and therefore you can't have them come back into work. If their job can be done remotely, it's pretty much game over. That's a reasonable accommodation. I can't think of a scenario where that would not be considered a reasonable accommodation as long as that job can be done outside of the office. Any questions about the ADA portion of it? Okay, we have a couple in the chat. Yeah, there's a question about New York law. There are no laws in New York against this, is going back to non-competes. So I would check on that. Scrolling down. Good question about flu shots, the traditional flu. It's can we not have them sign a form about reaction? I'm guessing no. Provider will administer without that sort of consent. I would say let your provider, typically it's a nurse or nurse practitioner that comes in and administers and they go through their form. Let them do that. And then if you have a employee for the flu shot who won't take it, I would not exclude them from work for that. This COVID guidance, I would not let it bleed over into their traditional flu shots. Now, a good question. What if an employee has the antibodies because they've had the virus and they don't want to be vaccinated? Great question. And in that situation, if the employee has the antibodies either through a prior vaccination or they had it, currently, I think you let them come back. You should look at the CDC guidance and your state and local. And I have a slide that's going to cover this a little bit at the very end because the CDC issued guidance that I think is a game changer. So let me hold off on that question before I go any further about people with the antibodies or who have been vaccinated. But I do think if they can show you proof of that, I would ask their doctor. I'd ask them to get a doctor's note showing me that they have that, which is equivalent to the vaccination proof. And then you have a reason to let them come back. Next question, for an essential on-site person who refuses vaccination, can you require additional safety equipment, masks, restricted location, etc.? Yes, I think you can. And I would encourage that because you're trying to make a reasonable accommodation for that employee. That is within your rights to do that. If they reject it, that gives you a reason to terminate because that is a reasonable accommodation, what you've outlined as I sit here today. No reason they shouldn't accept it. And if they're not and they have to be in the office, I think you can move to termination. Again, fact specific, talk to counsel, but I think you can do all that. Next question, I assume you cannot disclose to other employees who hasn't been vaccinated. The guidance is silent on that, but I agree with you. I would not disclose. It's no one's business. It's the employer's business. There may be managers who have a need to know why Tom has been put into his own office and you're not supposed to go in there. He's only, other restrictions. So you may have to tell some people, but I would keep that as confidential as possible. Great question. Do you think we can ask applicants about their vaccination status? We have staff working in the community with clients. Great question. I think, yes, you can. I think it's right now, the guidance seems to allow that because the EEOC has said, I can require you to be vaccinated before you come back to work. Coming back to work doesn't necessarily mean in the building. Coming back to work means doing what they do, as you described, working with clients in the community. So right now, I think that is a fair question, and one that you can ask, and then you'll have to go through the other scenarios that I laid out about the individualized assessment, etc. All right, that was it for the questions. Now, the religious accommodation requirement. So this applies if an employee tells you, I'm not vaccinated and I won't get vaccinated because of my sincerely held religious beliefs, practices, or observances. Okay, so what does the EEOC say about that? They really don't want you challenging an employee. They say you should just accept it if an employee tells you that. But if you're skeptical about the religious belief, you do have the right as the employer to request additional information. And I will tell you what, in cases I've had where this has come up pre-COVID for various reasons, I've had employees show up with letters from their pastor or religious leader saying they can't get whatever they're supposed to get due to their religious beliefs. Don't know whether you're going to want to challenge that. That's going to be fact specific. I would tend towards not challenging unless it's something really ridiculous. So let's assume someone comes to you with that reason for not getting vaccinated. They want to come back to work in the office or engaging with people as part of their job, as was that client question. We go back to what I went through with you in the ADA section. We do the individualized assessment. We look for those 4 factors, and then we look for reasonable accommodation. If no reasonable accommodation can be found, can you terminate? Well, then you still have to go through the leave available and other options like remote working, etc., as to whether or not that individual's religious belief can be accommodated and you can allow them to come back to work without being vaccinated. Okay, so it's the same framework. The undue hardship level to get to a position where you can say it's a direct threat is lower for the religious accommodation requirements. And what I mean by that is the undue hardship for an employer when you're looking at making reasonable accommodation. So the example we used to give with ADA, physical barrier compliance, the mom and pop grocery store now is required to put in an elevator. That could put them out of business. That could be considered an undue hardship for an employer versus AT&T having to retrofit a building with an elevator to accommodate someone with a disability. That's not going to be an undue hardship for them. Same kind of thing applies in that undue hardship checklist for the employer. Cost is an element, impact on your business, etc. What's the difference between the religious accommodation requirement, undue hardship, and the ADA? It's in the case law. I don't want to get too wonky here, but for religious, the employer only has to show that it's not a de minimis undue hardship, that there is some level of hardship, okay? That may be enough for you to say, we can't accommodate. If it's under an ADA framework, the case law has the undue hardship for ADA at a much higher level. You're going to have to prove a significant impact on your business. Again, I don't want to get too wonky on that stuff. If you're considering not letting an employee come back and terminating, and you feel you're at the undue hardship level after going through direct threat and reasonable accommodation, talk to your counsel. You may be able to go ahead and terminate. Now, these are the takeaways. What should you take away from this in terms of COVID? Well, number one, the focus is on your business needs and goals. And number two, keep in the back of your mind always the interactive process and reasonable accommodation. You're going to want to look around. What are other if you're a law firm, what are other law firms doing? Because that could be used against you if you go to litigation. Consideration should be given to the impact on recruitment and retention. Again, you have a lot of people who don't want to get vaccinated but want to come back to work. Is that impacting your business? That's something you're entitled to consider and look at. I think your employees, and this is just my opinion, would feel much more comfortable coming back if they know employees are required to be vaccinated or show proof of it. That may help you a lot in instilling confidence, lowering the fear level to get employees back into the workplace. What else? And these are pretty standard. You're probably already doing it. You got to establish your policies regarding PPE, sanitizing efforts. As more people come back, you're probably going to be stepping those up. Next, physical distancing and changes, use of plexiglass. You're probably already doing it, but as more people come back in, look at stepping that up. Rotating office shifts, remote working, another good employer tool in your toolbox to encourage more people to come back. Use of reasonable accommodations always in the mix in your toolbox. And again, like I said earlier, with the prevalence of remote working during the pandemic, you're really going to be hard pressed to say you can't work remotely unless that job is required to be location specific. And you're going to want to have that in your job description or at least some information about that, so you can show to an investigator that that's why you had to get rid of that employee. I would recommend, as we gear up and return to work more, that you do keep track of what you're doing regarding COVID and the office environment, use of PPE, et cetera, et cetera. Show that, for example, if you're going to let more people back in the office starting on X date, show that you did an audit. You walked, or you had someone in HR walk around and do an audit. Be able to demonstrate that in writing. Keep records of it. If someone complains, you're going to want to keep records to show what you did to address the situation. For example, the person wanted a plexiglass barrier. That's something that's simple. Keep records showing that you did it. People will forget about what they did over time, and this litigation, if there is litigation, could go on for a long time. You should all have procedures for contact tracing. What does that mean? Know who's in your office and when. So if someone comes to you and tells you, hey, I just tested positive, you can interview them. They'll tell you who they were in contact with. You go to your list, you know who was in the office at that time, and you can engage your protocols at that point. Again, we could do a whole session on that, what you should do in that situation. But you need to know if someone tells you they were positive, you need to talk to the people who they potentially exposed or were exposed to. And most importantly, you got to keep track of all the newly enacted federal, state, and local policies and leave policies. And let me give you an example of that. What we're learning here is as the vaccines roll out, things are changing. I now just heard a news report that there's already a booster shot out that people can get who may have already been exposed and recovered, and or who got vaccines early and now they can get a booster. That's an example of how things are going to change. The EEOC, the CDC, and OSHA will be continually putting out guidance about COVID and the return to work. And I think it's critically important you stay abreast of that. Your state and local governments, what do I mean by that? DC, we're in phase 2. It's still kind of promoting remote working, don't come in if you don't need to, etc. We're going to start moving into different phases. You got to look at those phases. If there are restrictions on the number of employees who can come in, are there other restrictions that a state or local government has put out? That is something you're going to want to be up on as you return to work. You can keep abreast of that in any number of ways. And I would even look at it on the county level. As we know in this region, some of our state counties in Maryland and Virginia have more restrictive, more business restrictions. You need to be aware of those, particularly office occupancy. Now, this is the game changer, in my opinion. This recently came out. And why is it a game changer? I look at this as something that is really encouraging to having employees come back in the office. And why is that? Because you don't have to quarantine everybody. If someone comes in and says, hey, I just tested positive, well, if everyone they worked with meets these criteria, in other words, they have been vaccinated, they got both doses, 2 weeks have passed since the second dose, and less than 3 months since they were fully vaccinated, and they don't have symptoms, those employees can keep coming to work. It doesn't matter if they were exposed to someone who tested positive. This guidance is the exact type of guidance that I think is going to be changing in the months to come, and certainly before year end, as more people are vaccinated, as we get herd immunity, as new vaccines come out, and for example, the booster. But New York State has adopted this. No one here has specifically adopted it, but this is yet another reason why you want to know about this guidance and why you want to follow it. And let me give you an example. Let's say there is litigation brought by an employee or group of employees because they got exposed and bad things happened, okay? What's the best position for the employer to be in? Number one, I was following the CDC guidance, I followed the EEOC guidance, and I followed my state and local guidance. If you're doing all that, you have a really strong defense to any potential claim. And you're able to show, for example, here are my audit reports for our office space, making sure there was PPE available, addressing complaints that have been raised, et cetera, et cetera. Being able to demonstrate all of this is going to put you as the employer in the best position to defend any potential lawsuit or anything that could come down the pike. I think we might see this guidance changing, particularly as more people come into the workplace. They may allow more people to be in one room at the same time for longer durations, depending on the percentage of people vaccinated. And that's another good reason. If you're going to require employees to be vaccinated and show you proof, you're going to have those numbers. You're going to know, for example, that 90% of my workforce has been vaccinated within the last 3 months. So the fact that 2 clients came in and later told us they were positive, I don't have to shut down. I can stay open. And I can show now through my record keeping, the office suite was cleaned shortly after they left, within a couple hours as part of our normal cleaning. Things of that nature are going to be important. And you may even want to work with your building management to see what they're doing to keep track of COVID cleaning, because at some point you may need to draw upon that. Again, I think this is a real game changer, and it's going to help businesses reopen and not shut down just because a positive case has come in or you've been notified about a positive case. All right, let me go to the questions in the chat. So one question is, what about an employee that works in a school? Wouldn't that present a strong argument for termination of an employee who refuses to get the vaccine? That's a hot topic question now, right? With the return to school and everything that's going on with that. In that situation, if you're a school, you're going to have to go through the same protocol, arguably. In other words, do they pose a direct threat of substantial harm if they won't get vaccinated? Potentially, yes. Now, can we reasonably accommodate? There's an argument that they can work remotely and still teach. So it's going to be that same process. It's going to be very fact specific, so I can't give you a definitive answer, but you're going to have to go through the same protocol that I just walked everyone through, absent a collective bargaining agreement or some other outside influence. So the CDC guidance we just went through, the question is, doesn't the CDC guidance only apply for the period between the 2 weeks and 3 months? After the 3 months, we're back to square one. Right now, that's exactly how it reads. So it's that window, but as I said, they may start recommending these, and this is all speculation, but the announcement of the booster shot, if the CDC recommends the booster after 3 months, it's going to have a shelf life of another period of months. So that's an example of what I mean by I expect that guidance to change as new vaccines, new protocols come out. So that 3-month window could very easily expand. So again, keep an eye on the CDC, your state and local guidance as well. And I think that's it for the questions that I see. If there are any more questions, go ahead and send them. And this is a first. We finished early. Whoop, got another question. Oh, well, thank you. Finished first, but that's because of the Department of Labor guidance wiped out all those slides regarding independent contractor. We will, if any new guidance comes out on that, we will get it up on our website. Those of you who monitor our COVID hub, it'll be popping up if we do that, or when it comes out. Got another question. Should we require proof of vaccination from everyone? Yeah, anyone who's coming back to work, I would say yes. So if the person's permanently remote working, that's not that important. But if they tell you they want to come into the office, or they want to go to a client's office, or they have that one question I had before, they have to interact with clients out in public, I think you're going to want to have that person vaccinated and make it a requirement. If they don't want to get vaccinated, then you go through the steps we discussed. But return to work can mean much more than just coming into the office. And the examples I gave are the people who work at client offices or have to go engage with clients, et cetera. And we have the same questions as lawyers about going back to court. Are the courts going to require everyone to get vaccinated? So far, not yet, but are you going to get the juries to come back in without that? So it's an ever evolving situation, but to answer your question, I say yes, require proof of vaccination from everyone. Well, thank you, everyone. Hopefully we'll get to do this live sometime soon. It'd be good to see everybody's face. If you're remote working again, I hope it's in some exotic place. But thank you very much. I appreciate the opportunity to speak again.